Explanation this morning. How confident are you about judgments at future days?
When I handle cases, God is always on the throne. In the case of Nambikano, God has taken over the entire proceedings. There's no question about that. We all saw it in court today. The truth is that the lower court tried in striking out 8 out of the 15 amended count charges. But the lower court fell far short in not striking out the remaining 7 counts. And what prima facie, they are dead on arrival, and they were dead on arrival, as I termed them, as dead as dead. But instead of the lower court striking out the entire 15 count charge and allowing Nnamdi Kanu to go home a free man after the long walk, like Nelson Mandela, long walk to freedom, the lower court retained 7 of the counts. And we are here to say, intermediate court, court of appeal, strike out this remaining 7 counts, because the lower court never calmly looked at the documentary evidence we placed before it. The respondent, the federal government, the DSS, they never responded to the critical issues we raised, that Nnamdi Kanu was forcefully abducted in Kenya and tortured and forcefully renditioned to Nigeria on the 27th of June, 2021, against the provisions of the Terrorism Prevention Act, under which he is being charged, against the provisions of the Extradition Act, against the provisions of the African Charter on Human and People's Ratification Act, Rights Act. And the law is that when you want to take a person from another country, like Nnamdi Kanu from Kenya, you have to go through a certain extradition procedure. If you don't, the detaining authority, that is Kenya, have to first give you consent or permission that you can take away this subject from our jurisdiction. Kenya did not do that. In fact, Kenya said, we never told them to take Nnamdi Kanu away from here. So what the government did was to apply brute force, jet amaze, in a most savage manner, by capturing Nnamdi Kanu the same way the federal government had done against Umaru Diko, who was Shagari's minister. And we have cited several cases before the court in other jurisdictions to show that a person you have brought in forcefully cannot stand trial on counts that were existing before you brought him back, which did not amount to the offense you are now saying he has committed. And by the way, the Federal High Court Act, the Administration of Criminal Justice Act, and Supreme Court and Court of Appeal decisions say when you are charging a person for a criminal offense, you must state with particulars the place where he allegedly committed the offense, the time, the venue. But in this case, all the remaining 7 counts, they are saying, 6 of them, that Nnamdi Kanu made certain broadcasts. Broadcasts from where? From the spirit world? You did not tell us. From Ghostland? You did not tell us. And you know what they did? That was because in our earlier objection to the first charge, where they said he made the broadcast from the United Kingdom, they tried to run away from that by now saying he made the broadcast without stating where he made it broke up. And the law is that you cannot charge a person in such a vague and invasive manner. The Federal High Court does not have global jurisdiction over crimes allegedly committed in other parts of Nigeria. The only count that they mentioned a venue was one of the counts where he was accused of importing a transmitter, and that it was accosted at Obulo Isuzo in Ihiala local government area of Anambra State. Of course, Ihiala local government area of Anambra State is not within the jurisdiction of the Federal High Court, such as to preside over the matter against Nnamdi Kanu in that respect. There is another point also, which is that he's being tried for allegedly committing these acts as a member or leader of IPOB. Because according to the federal government, IPOB has been banned or proscribed. Meanwhile, we have since filed an appeal against this proscription, and the appeal is pending, is extant before the same court, at the Court of Appeal. And you cannot begin to carry out a charge against a person based on a foundation which we are telling the Court of Appeal to remove. The question you should ask yourself is simple. Were Nnamdi Kanu to, and the Court of Appeal later finds out or discovers that unlawfully and wrongfully proscribed, what do you do about that? So we are saying they should, the law is that they should wait. Whether the doctrine of this pendant, they should wait first for this court to determine the proscription of IPOB, whether it was lawful or illegal. And they are jumping the gun. So all in all, Nnamdi Kanu has no case against him at all. He's being kept in detention by the same DSS who investigated him, the same DSS who arrested him, the same DSS is detaining him, the same DSS is still keeping him in custody, the same DSS through the federal government is also prosecuting him. So where is the justice when you are the investigator, the arrestor, the accuser, and the prosecutor? Where is the justice? Justice is not only for the government, it's also for citizens like Nnamdi Kanu. Nnamdi Kanu has not done anything wrong, and we have been able to demonstrate now, as we did before the law court, that Nnamdi Kanu never jumped bail. You jump, you escape trial. We all saw that on the 16th of September 2017, Nnamdi Kanu was with his late father, Eze Kanu, in his ancestral home at Umuahia, Afara Ibeku, Umuahia, Abia State, when the federal government, using the army through Operation Python, invaded the home and killed in cold blood 28 unarmed Nigerians. Nnamdi Kanu managed to escape by providence. Are you saying that he should have waited for you to kill him when every evidence pointed to the fact that he was to be eliminated? And when he escaped to Israel, he quickly deposed on affidavit, giving circumstances order which him. So he never jumped bail. This thing must be clear to the public. That Nnamdi Kanu was enjoying his bail from 2015. He never jumped bail for 1 day until they forced him to flee. So by the grace of God, this is a case where the justice of the matter points in the direction that the remaining 7 counts charged still pending against Nnamdi Kanu before the lower court, Joseph Netanyahu, will be struck out by this Court of Appeal. And Nnamdi Kanu, after the long walk, will to freedom and will become a free man. And by the way, it is even bicycle that he walks into freedom. Because if you, as we speak today, I learned the entire Southeast is in a lockdown. Now the Kano has therefore become a metaphor for the struggle of a people, the indigo race, who are saying, according to them, under their name of Biafra, give us self-determination. Self-determination is allowed by all international conventions, even by the United Nations Declaration of Human Rights and United Nations Convention, all the various conventions. Self-determination is allowed. And he's saying, let my people, and he never did that violently. We all saw that Igbo people were always on the street marching, blowing whistle, wearing berets. They never killed anybody until the government used violence. Today, for example, the judiciary wants that. Let us all do this amity. This country is one and it belongs to all of us. So I believe by the grace of God that we now become
Thank you, sir.
No, that make I want to eat that one. I have my mind.